Right, then we resume the hearing, and it's now time for the rebuttal for the respondent. Mr. Smith, please proceed.
Thank you very much, Mr. President, members of the tribunal. I'd like to begin this afternoon by responding to the specific questions that the tribunal has posed this morning. The first question I would like to respond to is with regard to Costa Rica's reference to the principle of effect útil and in their non-disputing party submission as regards the waiver requirement in CAFTA Article 10.18.2. In their affirmative submission this morning, claimants indicated that they agree that the principle of effect útil is applicable to CAFTA and to the waiver requirement, and El Salvador also agrees that this is a fundamental principle of treaty interpretation and it would apply to the interpretation of CAFTA. As regards the decision in Mobile versus Venezuela, my understanding of that decision is that the tribunal came to the conclusion that while this principle applies to treaty interpretation, it does not apply to the interpretation of the unilateral acts of states. For instance, it would apply to the interpretation of CAFTA, it would apply to the interpretation of the ICSID Convention, but it would not, for example, apply to the interpretation of the investment law of El Salvador, which under international law is considered a unilateral act. In fact, the decision regarding effect útil at paragraph 23 of the Mobile versus Venezuela decision was a discussion of Venezuela's investment law as a unilateral act, and the decision of the tribunal was that because that investment law is a unilateral act, it is not to be interpreted under the principle of effect útil. If we apply the principle to the waiver requirement, well, let's just say this, as applying the principle to the waiver requirement is proper, as Costa Rica did, it also leads to the conclusion that in this case, the waiver must be understood to include the obligation to comply with the terms of the waiver. Otherwise, there would have been no way to terminate the proceeding in El Salvador. The waiver requirement would be deprived of all effectiveness if the claimants had no obligation to withdraw their proceedings, to discontinue their proceedings in El Salvador, because there would have been no way for the waiver requirement to be complied with. The state would not be able to would not be able to cause compliance, and the claimants, if they did not cause compliance, obviously, if the claimants had no obligation to comply, then the waiver itself would be completely without any effect. The next question posed by the tribunal was with regard to the discontinuance of proceedings before the Supreme Court of El Salvador under Article 40 of the administrative jurisdiction law. In the short time that we have had over the lunch break to look at this issue, it hasn't been possible for me to come to a conclusion as to whether that withdrawal would be with or without prejudice, both looking at Article 40 itself and also the Salvadoran Civil Code. And I would not like to put forward an opinion on a complicated matter of Salvadoran procedural law without being certain of the conclusion, and I would ask the tribunal to give us the opportunity to consult with local counsel and do some research and provide, perhaps in writing, in a time period established by the tribunal, an answer to the question of whether that termination of the proceeding would be with or without prejudice.
You would like an answer from the tribunal now? Or for the...
No,
regarding
I'm
that
just saying
suggestion?
that is our position. The tribunal does not have to give an answer now.
While you're at it, how many days do you need for that?
I would think a minimum of 7 days. I would like to have 14 if possible.
No, but you are mindful that we are on expedited proceedings.
Okay, 7 is fine.
7 real days. Okay, thank you.
Okay, 7 real days, yes. The next question posed by the tribunal was the question of whether the statements of the CAFTA state parties would be considered subsequent practice in accordance with the Vienna Convention on the Law of Treaties, Article 31(3)(b). That article indicates that there shall be taken into account in interpreting a treaty, together with the context, any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation. Without a doubt, the statements of the CAFTA parties, both in the context of arbitration hearings where they're acting as respondent and putting forward legal briefs which state their legal positions, as well as in submitting non-disputing party submissions in CAFTA proceedings, are subsequent practice to the treaty. We do not have subsequent practice of all 7 CAFTA members, so it is not possible to reach the conclusion that there is an agreement among all of the CAFTA members. I think it is, however, possible to say that the acts of these states are subsequent practice and signify the agreement of those states who have engaged in that practice. Yes.
Would you then state that these positions taken by the states, at least a number of them, it's not all 7 as you indicated, Honduras, for example, has not taken a position, or not been in a position to take a position, that would be more accurate in that respect, is equivalent to, for example, the interpretive note of 2001 of the NAFTA parties. I don't know whether you're familiar with that note. Don't worry if you're
right.
not, then you have to ask somebody else what the note means. But they took the NAFTA parties sat together and then said, well, look, we want, for example, the minimum requirement to be interpreted in this way.
It is not the equivalent of the interpretive note, because the interpretive note is a statement by all of the parties, which would in fact, I think, be a subsequent agreement between the parties regarding the interpretation of the treaty under Vienna Convention Article 31(3)(a).
Thank you.
It is, in this regard, notable in this context that the claimant here, who is only a third-party beneficiary of the treaty signed by its state of nationality, is actually asserting an interpretation of the treaty that contradicts the interpretation of its state of nationality. I think that that is an important thing an important point for the tribunal to keep in mind as a investor under a treaty such as CAFTA is not a party to the treaty. It is a third-party beneficiary to that treaty and is acting in a way and putting forward an interpretation that actually contradicts the interpretation of the state of which it is a national. The next question posed by the tribunal is whether the government of El Salvador may oppose discontinuance of a case before the Supreme Court, and a case under the Administrative Procedure Law of El Salvador. And it is clear to us that the government cannot prevent discontinuance. Article 40 of that law makes clear that the claimant may terminate the proceedings without the consent of the government, and the government cannot prevent termination. The next question has regards, although it was posed to the claimants, it also was directed to us. It regards the value or the extent to which dissenting opinions can or should be followed by arbitration tribunals. The first point is that it's very clear that only the award in an arbitration has legal effect. A dissenting opinion has no legal effect. El Salvador agrees with the statement of the Waste Management II Tribunal that only the majority of the tribunal, speaking as the tribunal, could determine the effect of its decision. El Salvador also believes that dissenting opinions are clearly less persuasive than the awards of arbitration tribunals, in part because they're almost always issued by party-appointed arbitrators, as in the case of the dissenting opinion of Keith Hyatt in Waste Management I. Obviously, dissenting opinions are very often written by very learned legal scholars, and to the extent that they are in and of themselves persuasive as legal scholarship, they certainly do not need to be ignored, but as legal authority, they do not have any binding legal effect. Finally, the tribunal raised a question with regard to whether the waiver in CAFTA Article 10.18.2 applies to any proceeding on the investment law of El Salvador, and particularly whether that waiver would apply to proceedings on the investment law before this tribunal. El Salvador maintains that, in fact, the waiver applies to all proceedings other than CAFTA proceedings before this tribunal, including investment law proceedings, whether they be brought before this tribunal or before any other tribunal. If we could bring 10.18.2 up on the screen. Can we maybe, do you have one of the versions? Because that's not here. What's that? Oh, there's something. Okay. Can you pull out? Okay, that's better. The waiver is of any right to initiate or continue before any administrative tribunal or court under the law of any party or other dispute settlement procedures, any proceeding with respect to any measure. It is the view of El Salvador that the adjudication of claims under the investment law is a proceeding within the meaning of any proceeding, and it is a proceeding even when those claims are adjudicated before the same tribunal as the CAFTA claims. The fact that there's a single tribunal doesn't make the CAFTA proceeding and the investment law proceeding the same proceeding. The reference to other dispute settlement procedures is not a reference to dispute settlement procedures other than this tribunal. El Salvador is not arguing that this tribunal is somehow a dispute proceeding other than itself. Other dispute settlement procedures is to distinguish it from local proceedings. It essentially could be read international arbitration. So it is clearly El Salvador's position that the waiver would apply to investment law proceedings even before this tribunal. Of course, this issue in the understanding of El Salvador is not currently before the tribunal for decision. El Salvador certainly reserves its right to raise it in jurisdictional objections at a later time, but doesn't consider that issue has been placed before the tribunal at this time for decision. I also want to mention the decision in the PAC-RIM versus El Salvador case mentioned by claimant this morning. No doubt that decision was issued, but it was a decision under the expedited proceedings under CAFTA 10.20.5, which was without prejudice for El Salvador to raise the issue again in jurisdictional objections at a later time. In fact, El Salvador has raised the issue again, and so in El Salvador's view, that decision is not a final decision. It's a decision still subject to further review by the tribunal that issued it, and it will not become final until that further review has been completed. I believe with that I've answered all of the tribunal's questions. If I've left anything unanswered, please let me know.
We have one further question for you,
Yes.
for Respondent. Obviously also the claimants may wish to comment on this, and that is this. What is the legal basis for Respondent to state that claimants should have acted beyond the text of Article 10.18.2? And this means what the text says is that, put it colloquially, a piece of paper has to be added to the notice of arbitration, in which it says, we waive any right to initiate or continue, etc.
Okay. Yes.
You take it one step further, says, and what the respondent says, and you should have, therefore, actively discontinued proceedings in El Salvador before the Supreme Court. So what is the legal basis? And what I heard this morning from you was two bases, and then we heard this morning you saying implied obligation, and we read your submissions, there was a reference to good faith. Could you enlighten us more on what the legal basis is
Yes.
for taking that position?
Could you bring that up again? The text, again, I going back to the interpretation of treaties, because here we are interpreting a treaty, and Article 31 of the Vienna Convention on the Law of Treaties does state that a treaty must be interpreted in good faith in accordance with the ordinary meaning to be given the terms of the treaty in their context and in the light of their object and purpose. The text says no claim may be submitted to arbitration under this section unless claimants submit a written waiver. Now, so there is the term waiver, and there is a meaning under law and an understood meaning of the term waiver, and El Salvador would submit that the term waiver includes two aspects. One is a formal submission of the waiver, and the second is the material compliance, the material aspect of the waiver, which is to act in conformity with the waiver. And the good faith requirement comes in that when a party makes an irrevocable final decision, that is, they put forward a waiver that binds them in law, that they have the obligation to comply with that waiver, and that obligation is part of the meaning of the word waiver. If implicit may be the right word, but when states use the term waiver, states mean formally waive and materially waive, which means acting in compliance with the waiver. And this is precisely the interpretation that the Waste Management 1 tribunal gave to NAFTA, and it is the interpretation that all but one of the state's parties have also given to this text.
But the text itself says a written waiver, and that, at least textually, would refer to a document. And if I listen to the claimants, they say, well, look, that is what we have done. We have submitted that document. It's a written waiver, and we've actually repeated the text here. And what Waste Management 1 apparently does is go beyond that. Says, well, look, now we're going to distinguish between the formal requirement, which is that written document, and we take it one step further, and there's also a material requirement. And do you arrive at by means of interpretation? And which rule of interpretation do you use then?
It is El Salvador's position that the use of the term waiver includes the material aspect of a waiver. That is, it is included in the meaning of the term. It is in the plain meaning of the text within the use of the word waiver.
But if you use the expression written waiver, then you disconnect the word written from waiver. I don't want to be parsing the language here too much, but...
Right, no, well, let me address that. Written waiver as opposed to oral waiver. That is, if the waiver, in order to be valid, must be in writing. It's a requirement to put it in writing. It is not a distinction to say that it is a written waiver and therefore only a formal waiver. It has to be in writing. If it were presented orally, it would be invalid. Written is just to indicate that the form of the waiver must be in writing, but it does not change the meaning of the word waiver.
Yeah,
so, if I understand you correctly, the waiver, the written waiver that would be required under this provision should say, and we have submitted a waiver in writing before the Salvadorian Supreme Court. Those words should have been included into the waiver to be a waiver qualified under the treaty.
No, the waiver would not need to include those words. The waiver includes the requirement to act in conformity with the waiver. That is, the fact that it is a waiver means that there is a material requirement to comply with the waiver. So it is the act of issuing the waiver that creates the requirement to act in conformity. The waiver does not need to have any additional language in order for it to include a material requirement. The waiver as stands would includes the requirement to act in good faith in accordance with the waiver.
Thank you.
Now I'll turn. Sure. Yes.
I'll just ask a question. Are the parties in agreement that the only relevant date for evaluating the waiver is the date of the submission of the claim?
I don't think I can give a yes or no answer to that question. El Salvador agrees that the waiver must be valid on the date that it is submitted. El Salvador agrees that as a general rule in international arbitration law, jurisdiction is determined on the date of filing of, or the date of initiation of arbitration proceedings. That doesn't necessarily mean that acts that take place after that date are irrelevant to the validity of the waiver. That is the key date. but the validity of the waiver depends, as the Waste Management Tribunal indicated, on the good faith intent of the party to comply with the waiver. Subsequent acts may be evidence that the waiver was invalid on the date that it was filed. Similarly, the fact that the waiver is filed on the date of the notice of arbitration, and that is the date for determining jurisdiction, that clearly, and as admitted by claimants, does not mean that pre-waiver, that conduct before that date is not relevant. On the question for the tribunal is, was the waiver valid when filed? El Salvador's position is that because the claimants did not take steps to terminate the proceedings, and at the date of filing had taken no such steps, and the proceedings continued, they continued the proceedings, the waiver was invalid. That implies that they must have taken some steps prior to filing, but the date, as you've indicated, the crucial date is the date of filing. But there are relevant actions before and after in actions relevant to evaluating the validity of the waiver on that date. I hope that answers your question.
Do I take that to mean, I'm mindful of what was said in the RDC case, where there's a discussion of the overlap of claims. Are you saying to us that if there were domestic proceedings extant as of the date of the filing of the waiver, that a proper waiver cannot be given? Is that your argument? It's not possible for the claimant to give a proper waiver if there are extant domestic proceedings in relation to the same measure?
Again, the requirement is that the claimant act in conformity with the waiver. That is, it comply with the material requirement that is inherent in the issuance of a waiver, inherent in the term of a waiver. So it is whether or not they have complied with their obligations under the waiver that is determinative. It may be that the proceedings are still continuing because they've taken steps to comply by requesting discontinuance, and that discontinuance has not happened yet. Okay? Am I being clear? That is, the focus is on the waiver itself and the validity of the waiver, and it is on the actions of the claimants in complying with the material aspect of the waiver. Not necessarily with what is happening in the proceedings themselves. I would like to move now to some rebuttal points as to what was said by the claimants this morning. Claimants spent a considerable amount of time discussing the letters sent by El Salvador at the initiation of this arbitration and indicating what those letters told them or did not tell them they should do. They've indicated that they did not comply with the waivers because El Salvador said in its letters, told them that withdrawing the local proceedings would not cure jurisdiction. But the obligation to comply with the waiver does not come from El Salvador's letters. Claimants had the obligation under CAFTA. And they did have a way to comply and preserve their CAFTA claims, but they chose not to use it. El Salvador had nothing to do with this. El Salvador did not have an obligation to send the claimants a letter saying, if you take the following steps, the problems we have pointed out to you might be cured. Claimants are in a position to hire counsel to study issues and to understand international arbitration proceedings. The burden is not on El Salvador to tell them how they need to act in order to preserve their claims. El Salvador was simply putting them on notice that there was a defect in their waivers, that El Salvador offered them the opportunity to withdraw the arbitration in order to avoid what we have gone through over the past months and this hearing, which has cost El Salvador a considerable amount of money, which should have been avoided because claimants should have understood their waivers, should have understood international law, and should have complied with their waivers. What El Salvador said or did not say in its letters is not determinative in any way of the obligations of the claimants. On a further point, claimants continued this morning to rely on a view of the purpose of the waiver that is impracticable. Let me just go back, because I think I didn't restate the way in which they could have preserved their claims. They had the opportunity to withdraw this arbitration, withdraw their, seek discontinuance of the proceedings before the Supreme Court of El Salvador, and then reinitiate arbitration. They chose not to do that because of the time bar in CAFTA. They have lost the opportunity to do that, but that was a choice that they made. Claimants claim, moving on to the next point, claimants claim that the sole purpose of the waiver is to let states seek dismissal of cases brought against them. They continue to say that regardless of the solemn commitment in the waiver gives them no obligation to do anything. They may allow as many proceedings as they want to continue, and it would appear they may initiate as many proceedings as they want, and the waiver only serves for the state to go around and try to defeat those proceedings. That is what they said that El Salvador should have done in El Salvador. But we've pointed out this morning that the waiver would be ineffective protection for El Salvador in this circumstance. Without a doubt, part of the purpose of the waiver was to arm states with a way to try to defeat proceedings, as Venezuela did with regard to the Vanessa Ventures case. But the waiver also generates obligations on claimants to end proceedings, to not initiate proceedings, to not pursue proceedings. There are two pieces to that protection, and claimants want to rely on only one, and one that in this case and in many cases would be ineffective for states. With regard to the letters sent by the Attorney General of El Salvador and Counsel for El Salvador, the claimants stated that they were not the recipients of those letters and had to request those letters to get copies. But it's true that they weren't the recipients, but the ICSID Secretariat, as it always does and is very efficient in doing, sent the letters to Counsel for Claimants within 2 days of their filing. And the fact that the letters were not addressed to claimants doesn't mean that the claimants should not pay attention to them and could not have taken heed of them and acted in consequence if that is what the claimants wanted to do. The fact that they were not addressed to them doesn't mean that they were not made aware of them and given copies of them. And finally, in a related point to this, as regards to the date of filing of the claim, the ICSID Secretary General's letter acknowledging receipt of the claim states that the date of receipt was July 6, 2009, not July 2, 2009. Finally, I want to address claimants' misrepresentation of the Waste Management 1 decision. that? Can you? That tribunal clearly stated that the waiver was defective for two reasons. Because there was a formal defect in the addition of reservation language, and because there was a material defect created by noncompliance. Claimants, again, read only half of the quote, leaving out the last clause of the sentence. They did this in their pleading, and they did it again today. The full quote is, based on the foregoing, it is clear that claimant issued a statement of intent different from that required in a waiver pursuant to NAFTA Article 1121, since it continued with the proceedings initiated against Bonabras after the date of submission of the waiver, September 29 September 1998, until all avenues of recourse had been exhausted. The continuation of the proceedings was a key part to the tribunal's conclusion that claimant had filed waivers that were defective. And it's the same situation as exists in this case. It is the claimant's actions that created the defective waivers because they did not act in conformity with those waivers. In conclusion, Mr. President and members of the tribunal, El Salvador believes that it has demonstrated and affirms that the claimants did not comply with the waiver requirements of Article 10.18.2. The waiver requirement is a condition of consent. Consent is a condition of jurisdiction. Because they did not meet those requirements, there is no jurisdiction, and this entire arbitration must be dismissed. Thank you very much.
Thank you, Mr. Smith. Does the claimants want to have a short time out? How much do you need?
15 minutes, please.
15 minutes, okay. Recess 15 minutes.
Thank you very much.